Committee will come to order. At the conclusion of opening statements yesterday, the chair called up H.R. 2576, TSCA Modernization Act of 2015, and the bill was open for amendment at any point. And before I ask if there are bipartisan amendments to the bill, I'm just going to strike the last word for a minute or two, and I just want to extend my thanks and my gratitude to players on both sides of the aisle, particularly Mr. Tomko and Mr. Pallone, and certainly Mr. Shimkus on our side, getting a bill that we could see pass with a very, very strong vote when we finish. This has been in the works. We haven't modernized this in literally 40 years. We thought we were coming close in the last Congress, and I decided with Mr. Shimkus and others that though we could pass a bill, it would be pretty much along party lines. We could pass it on the House floor, but we probably wouldn't see it go through the Senate, and we would have wasted a lot of really hard work. And we came to the conclusion last summer that it would be better to wait. Time would help us, and thanks to the good work, particularly on the Democratic side of the aisle, and our great staff, we were able to put together, I think, a very strong bipartisan bill that has great opportunity of working with the Senate. I look at our friends Tom Udall and Jim Inhofe over there, and it looks very much that we will get a bill pretty close to the President's desk that looks a lot like what we're going to be doing here in full committee, and work with the Senate to get a bill done. And it is a great accomplishment for something that really deserves a lot of attention. And I can say, as a Midwesterner, as I look at my friends in New Jersey, and I look at Mr. Lance, I certainly look at Mr. Pallone, this means a lot to states with heavy chemical industry in their states. I look to the South as well, Mr. Scalise and others, and I can name a lot of members here. But it is, I think, a real fine accomplishment that we came together on a bill that could have a similar vote to what we did with the Cures Act 2 weeks ago. So I just want to say thank you.
Would the gentleman yield?
Yield to the...
I just wanted to echo what you said. If anybody told me, a year or two ago, or even 6 months ago, that we could have come up with a strong compromise bill, I would have said, that wasn't very likely. But I do think that it's because of you, Mr. Shimkus, the staff, Mr. Tonka, so many people that we have been able to work this out. And it is a strong compromise bill that will empower EPA and better protect the American public, which is so important to so many of us. I mentioned New Jersey in particular. And again, I think it's an example, as with 21st Century Cures, of how this committee can work together and produce bipartisan legislation that, ultimately becomes law, which is really the only purpose, in my opinion, of our being here. So I just want to say that I fully support the bill, and I appreciate the process that's got us here. Thank you.
Well, thank you. No. Reclaiming my time, which never started. I will now ask if there are any bipartisan amendments to the bill.
Mr. Chairman.
I'm looking. Yes, Mr. Shimkus.
I have an amendment at the desk.
Is it a bipartisan amendment?
Bipartisan.
Bipartisan.
I believe it is.
The clerk will report the title of the amendment.
Amendment to H.R. 2576, offered by Mr. Shimkus.
And without objection, the amendment will be considered as read. The staff will distribute the amendment, and the gentleman is recognized for 5 minutes in support of his amendment.
Thank you, Mr. Chairman. This is just a technical and conforming an amendment. It's agreed upon by the majority and minority staff, and with some input from the EPA. These should be non-controversial, and ask my colleagues to support it. And with that, I yield back my time.
Gentleman yields back. Other members wishing to speak on the amendment?
I'm just, if I could strike the last word and say that, yes, this is a technical amendment, and we do support it.
And gentleman yields back. Time has expired. All those in favor of the amendment offered by the gentleman from Illinois, please say yes. Yeah, aye, yes. Those opposed say no. Opinion of the chair, the ayes have it, and the amendment is agreed to. Are there other amendments to the bill? Gentlelady from California has an amendment at the desk.
Mr. Chairman, I have an amendment at the desk.
And the clerk will report the title.
Amendment to H.R. 2576, offered by Ms. Eschew.
And the amendment will be considered as read, and the gentlelady is recognized for 5 minutes as the staff distributes the amendment.
Thank you, Mr. Chairman. I think that this bill is going to go a long way toward improving our broken federal regulation of toxic chemicals. But I think it needs to be clarified with respect to its impact on state laws. In 1986, California voters passed a landmark Proposition 65 to require the listing and the labeling of toxic chemicals. Prop 65 has increased public awareness of toxic chemicals and has motivated many companies to reduce or eliminate these chemicals from their products. Other states have also passed important toxic chemical regulations, including New York's ban on BPA in children's products, North Carolina's ban on mercury in schools, Maryland's ban on cadmium in children's jewelry, and Vermont's ban on toxic flame retardants. In the absence of effective federal regulation, these state laws have provided critical protections against toxic chemicals and should be preserved to every extent possible. My amendment would make 2 minor changes to the savings provision of the bill based on the recommendations of 12 state attorneys general that have written to our committee, and I believe it was last week that the committee received their letter. This would clarify the savings provision to prevent litigation over vague terms and ensure that it achieves its intended purpose of protecting state laws and certainly Prop 65. First, my amendment would clarify the circumstances when an existing state law will be preempted by the bill. Under the current bill, an existing state law is preempted if it, quote, actually conflicts with a federal determination. To eliminate the need for litigation over this undefined term, my amendment would clarify that preemption only occurs when it's impossible to comply with both state and federal laws. For example, if an existing state law sets a limit for a chemical at 1% and the EPA sets a limit of 5%, under my amendment, the state law would not be preempted because it is possible to comply with both standards. Secondly, my amendment would clarify that the bill allows states to continue to enforce their existing state laws, unless preempted under the limited circumstances I just described. The underlying bill grandfathers any state action taken prior to August 1st of this year. As pointed out by the attorneys general in their letter, this could be interpreted narrowly to only protect ongoing enforcement actions taken prior to that date, rather than prior regulatory or legislative actions. This would mean that only active enforcement cases pending on August 1st, 2015 would be saved, and no future enforcement of state law could be performed. So my amendment would ensure that California and the other states mentioned can continue to enforce their strong state laws unless it's impossible for the parties to comply with both the state and federal standard. Again, Mr. Chairman, I commend my colleagues for putting this important bill forward and for including the savings provision to protect certain state regulation of toxic chemicals. I agree with 12 attorneys general that wrote to the committee that this provision needs to be clarified, and that's why I'm offering this amendment and urge members to support it. In particular, obviously, the members of this committee that are part of the state delegations listed on the Attorney General's letter, and they include Massachusetts, New York, Iowa, Oregon, Maryland, Vermont, and Washington State, to take note of their attorney generals that have written to us. So thank you, Mr. Chairman, and I yield back the balance of my time unless someone else would like the 26 seconds. Yield back.
Mr. Chairman, if I could strike the last word.
Gentleman is recognized for 5 minutes.
I just wanted to say that the issue that Ms. Eshu raises is very important. We've heard from the state AGs in these states, there are probably others that have similar concerns, and it is an issue that we need to address, before the bill goes to the floor, particularly if we're going to continue to have bipartisan support for the bill when it goes to the floor, which I know is so important to all of us. I do think, I don't think we really have time to deal with it today, and I would rather move the bill forward and not have this amendment voted on. But I do want to stress that it is something that needs to be addressed, because if it isn't addressed in some fashion, we will get significant opposition to the bill. So I was going to ask, obviously, I'd like to have more discussion, but I was hoping that we could have the discussion and then, get some response from you, Mr. Chairman, and then see if it's possible to not actually vote on this today. But I do want to stress how important it is if we're going to continue to have bipartisan support for the bill when it moves to the floor.
Does gentleman,
To you or however.
let me yield. Why don't I take 5 minutes and let me first yield to Mr. Shimkus.
Sure.
Thank you, Mr. Chairman. I appreciate my friend. We work closely together on many issues, Congresswoman Eshu, for her friendship and her work ethic, which I know is strong. And I know California is viewed as a national leader in many issues, and many times it deserves that credit for being a national leader. But I would be careful about pushing. We did the savings clause with the focus on making sure we were receptive to California concerns. And this is fine. We're trying to. What's brought us together here is 4 decades of a flawed law, and we think we've got it balanced where we can move it with a pretty good majority vote. My concern is that this pushes us over the limit and could really disrupt the bill as it moves forward. Not for your side, but for our side. Because what we've tried to do in the bill is say, once the EPA makes a final judgment on a chemical, but prior to that, the states can be involved and the states can be engaged. But once they make a final ruling of what chemical can use and how it can be used and how it should be in commerce, then there is state preemption, and that really just falls to the constitutional principles of the Interstate Commerce Clause, which there's always that fight, right? States' rights versus interstate commerce. But that's kind of why we have an Energy and Commerce Committee. I look forward to having further discussions, but I would just caution that push too far, this gets disrupted, and we'll come back here in the next Congress and try it again. And
Would
that,
the
I'll yield
gentleman
back.
yield?
Yeah, let me just let me reclaim my time, and I'll yield to you in a second. This bill has not been quite as hard as balancing basketballs on each other as we look at the time that we've taken, but it has been a carefully crafted, honest discussion and bill that we have today. We all know that preemption is a huge issue. We know that the Senate bill is fairly close to where the House bill is. They have different language than we have in this bill, and as I understand it, our bill is actually better under
Well, we always do everything
California.
better.
No, I know. We're always better, I know. But from the California perspective, which generally supports fairly strong preemption, our bill, I think, is closer to where that California test is than the Senate bill. And as we expect this bill to be on our House floor before the month is out, I'm not sure that we can negotiate something different than what we have now. Saying that, the Senate is behind us. They're not too far behind us. Expect that their bill could be up in July. We're going to have a lot of discussions, whether we go to conference or whatever. I mean, this will be part of that discussion. And I will just say for the record that from my perspective, I don't want us to slip from the California perspective further than where we are now. But, and if we did slip, it would be away from California. But there may be some things that we can do. We're open for that discussion, but prior to having this bill on the House floor, my guess is that we're not going to come to some bipartisan agreement ready for the floor. And I don't know if the gentleman, it's my
It's
time
his
still.
time. Let me just say, if I could just take
Yeah,
the
let
last
me just,
40 minutes.
I'll give you some time. I'll ask, do you want to comment on
No,
what
I'm-
all right, I'll yield back to my friend.
I just, well, first of all, everything we do is always better than the Senate,
I know.
needless to say. But look, I think that we've done a good job so far when things come up of trying to address them, even when they seem hopeless, maybe. This this came up, in the last, few days, and it needs to be addressed in some fashion. So all I'm really asking is that we have some sort of commitment over the next few days or weeks to try to address this. Because, again, I think that if on closer inspection, it may very well be that it is something that we can address. So that's my only point is, if we could at least agree that we're going to try to address it between now and the floor.
Well, let me just say, we'll continue to listen and have somewhat of an open mind.
Mr. Chairman?
But I just don't know with the time constraints that we could actually come up with something in the next 2 weeks or so. But the discussions will continue, particularly assuming that the Senate's going to move their bill, and we'll see where we are and what happens.
Mr. Chairman?
And my time is now expired, so let me go to you. This gentleman, I saw her hand first. Gentlelady from
I'm going to just strike the
Colorado.
last word. Mr. Chairman, this is the same issue that came up right before the subcommittee markup, the issue of preemption of state laws. And with the help of Mr. Shimkus, Mr. Tonko, and everybody else, and Mr. Green, we were able to negotiate some language. It is a real concern that Ms. Eshoo raises about preemption of state law. And part of the problem we have is even though the language in the original bill before the markup in subcommittee attempted to not preempt state law, in particular Prop 65 in California and other laws, there was some concern about the drafting of the language. And so actually we were able to come up with some compromise language before the subcommittee hearing that seemed to satisfy all parties. So as I look at this letter from the AGs, which I frankly have just seen, it seems to me that their concern is the same essential concern that was raised before the subcommittee hearing. And so I would think that if we all sat down with Ms. Eshoo, the other Californians and the other people who cared, and also the AGs and the trial lawyers and others to see if there was some way that we could make the language more clear. I think it would be in all of our interest, and I think that we could, I think it's worth looking at, and I wouldn't be so pessimistic.
If the
about
gentlelady will yield,
I'd be happy.
we'll be glad to.
Thank
We'll be glad to set up meetings and listen and just see if we can come to some agreement before it comes to the floor. But even if we're unable to do that, we'll continue to work and listen and see what we might be able to do. And again, I want to compliment all the folks that worked hard on where we are today.
Okay, I'll yield the rest of my time to Ms. Eshoo.
I thank the gentlewoman. Mr. Chairman, my intent is not to blow this bill up at all. It just isn't. I believe I started out by saying that this bill has gone a long way toward improving our broken federal regulation of toxic chemicals, and thanked all the members that have been involved in this. We really need to have a good, solid federal law. My record on preemption, I think is pretty strong. So it's not that I oppose that. I think there's always a time and a place for it. I just want these states to be able to, to be assured that their state laws, that they can implement what they have. And I don't think we have that far to go. And these are large delegations, Mr. Chairman, with a lot of votes. I mean, two of the largest states in the nation, California and New York. So there are a lot of votes in these delegations, which I think needs to be taken into consideration in a very pragmatic way. And I want to thank my friend John Shimkus for your good words and your excellent work on this. So when you take into consideration the number of votes between California, Massachusetts, New York, Iowa, Oregon, Maryland, Vermont, and Washington State, you've got to take that into consideration too. All I can say is that I'll withdraw the amendment with the understanding of what our ranking member has said, and I really don't think we have that much farther to go. I don't think you want trouble from these delegations when the bill is voted on, because again, I think the country needs a strong law relative to the regulation of toxic chemicals. There are some 80,000 of them, and they threaten the public's health, across the country. So, with that, I don't know if anyone wants. Do you want to reclaim your time, Diana? No?
If no one else wants it, I'll yield back.
Okay. Thank you. Thank you very much.
Are there other members wishing to speak on the amendment? Seeing none, does the gentlelady suggest to withdraw the amendment, or is she going to proceed? Gentlelady asks that her amendment be withdrawn. And I just want to, again, emphasize we'll continue to listen. We will. We want to make the bill to pass with a strong vote. And so certainly in the next couple of weeks, but even after the bill is scheduled for the floor, we'll continue to work with all sides, particularly with the Senate, to get language that we can support. So, are there further amendments to the bill? Gentlelady from Colorado.
Mr. Chairman, I just moved to strike the last word.
Gentlelady's recognized for 5 minutes.
I just want to thank you, Mr. Shimkus, Ranking Member Pallone, and Mr. Tonko for making this a priority. A lot of us have been working on TSCA for a long time, and all of the work from the last few years has paid off, and I just want to commend you. I don't think the American public realizes how bad the existing law is and how vulnerable it leaves us all to chemicals linked to cancer, developmental problems, and other issues. It's long past time that we update the law. As everybody said, this is a true compromise. But I do want to raise a couple of issues that I think we need to talk about as we go forward. I don't have an amendment, but I think it's important to put this in the record. We need to make sure the new law is going to equip EPA to protect us from the toxic chemicals over the long term. First of all, I'm worried that the industry-driven assessments under this bill could result in the EPA spending too much time on reviews important to the industry at the expense of time devoted to the chemicals of most danger to public health. There needs to be a balance in the EPA's workload. Second, as I have talked to your staff and others about this week, I remain concerned that the EPA testing authority is unclear. Outside of the risk evaluations that will now be directed specifically by law, EPA remains caught in a catch-22, where it's unable to require testing without evidence of risk. That should be clarified, and I look forward to working on report language that makes it clear that the EPA will have the data it needs to determine whether or not to initiate a risk evaluation. And the third issue that really is an issue if there are still problems with preemption, because certainly if we have states like California that are that have robust laws, we don't want to preempt those laws. So I really appreciate the hard work that's gone into this bill and the dedication of everybody to fixing this badly broken chemical safety law. But we're ultimately going to be judged by how well the law works in the next few decades. And so I hope we can continue these discussions, Mr. Chairman, to make sure that we have the most robust legislation going forward, either when it comes to the floor in the next few weeks or as it moves forward to the Senate. So, you know, I know I speak on behalf of Mr. Green and myself, Mr. Tonko, and others. This really has been a collaborative effort, and I applaud all of you for carrying it over the finish line. I'll yield to anybody who wants it, or I'll yield back. I'll yield to Ms. Clark.
I thank the gentlelady for yielding, and I want to again thank Chairman Upton and Ranking Member Pallone. While I'm in support of the bipartisan bill, I would like to raise for discussion that is my opinion that this bill does not adequately address what I perceive to be future issues concerning the disposal of toxic chemicals. The EPA administrator is not specifically directed to refer to more stringent environmental protections mandated under the Resource Conservation and Recovery Act. And this is particularly troubling for communities of color and low-income vulnerable communities that rely on the EPA for protection from lawless chemical dumping and inadequate cleanup and remediation should violations occur. So I hope that we would take another look at that, because this has been an issue for many communities across this nation. With that, I yield back to the gentlelady.
Gentlelady yields back, and the chair would recognize Mr. Schrader to strike the last word.
Thank you, Mr. Chairman. I want to commend Chairman Shimkus and Ranking Member Tonko, like everybody else, for all their hard work, and the chair and ranking member of the full committee, too, for bringing us together on this bill. It's easy for me to support a bill like this that has a huge bipartisan backing, and people have worked in good faith together and agree with what we can agree on and leave some other stuff behind. But in that regard, there is a portion of the bill that would fall under Section 8 I'd just like to bring to everyone's attention regarding the recycled byproducts. I think it's important to have a regulatory environment that incentivizes recycling and not taking some of this stuff to the landfill. I've been working with my fellow colleague, Congressman Johnson, on this issue, and I think there's a way we can focus EPA's resources in a way that doesn't discourage companies from doing the recycling here and provide for the human health and environment protections we want. So I'm not going to offer an amendment or anything like that. Just ask the chair and ranking member if they commit to continue the dialogue, maybe get some strong reporting language in the bill along these lines. And if I could, I'd like to yield the remaining of my time to Mr. Johnson.
Well, I want to thank my colleague for yielding, and it's a pleasure working with you on this very important issue. I'd like to also express my support for including strong language in the committee report for EPA to address this issue. We must make certain that current requirements are encouraging industry to recycle inorganic byproducts, not incentivizing them to landfill them. Simply put, our regulations should promote environmental protection and economic prosperity, not discourage it. Inclusion of this bipartisan language is common sense, especially when you consider that inorganic byproducts were not even subject to reporting for the first 30 years of the program because they pose such a low risk. Additionally, I would like to see language that addresses EPA's partial reporting exemption petition process for low current interest chemicals. Among other consideration factors, EPA's ability to apply a partial reporting exemption to a chemical substance is contingent on if the agency believes it has enough information about the chemical in question. However, there are cases in which the EPA has insisted it does not have enough information from a stakeholder petitioner without saying what more it needs. For instance, I'm aware of partial reporting exemption petitions that have taken up to 8 years to be acted on and denied without specifying what information it lacks. The current requirement is for petitions to receive a response in 120 days. In my view, the EPA should be directed at a minimum to provide a public notice and justification for any delay in responding to a petition beyond 120 days. So I'm hopeful that both of these issues receive the attention they deserve before the completion of this legislation, and I look forward to working continue working with the chairman and the ranking member on these Section 8 issues. And thanks again, Congressman Schrader, for letting me be a part of this. Mr. Chairman, I yield back.
Would the gentleman from Oregon yield? And just in response, I think we look forward to working with you. As we talk through this process, you heard of our interest. Again, I think the folks here in the room understand now how finely crafted and balanced this bill is, and we're sorry we couldn't get it where you wanted it to be, but I think we're going to commit to work on really strong report language to try to address some of the concerns that you and Congressman Johnson have raised, and we look forward to working with you. With that, I yield back.
Would the gentleman yield? I just want to thank my colleague, Mr. Schrader, for raising this issue. I think all members of the subcommittee have heard concerns from regulated industries about how EPA has implemented Section 8 of TSCA, and the committee has developed a very strong record on the major statutory problems in TSCA, but our record on Section 8 concerns is thin. The concerns also seem to be on the implementation side, not in statute. So I welcome the Chairman Shimkus' willingness to explore the concerns further, develop the record, and acknowledge the concerns possibly in report language rather than legislative text. This committee's oversight role is very important and will continue to be important if and when this bill becomes law, and I look forward to working together to investigate these concerns and any others that develop as EPA moves forward with implementation. So again, I thank the gentleman for yielding and yield back.
Gentleman yields back. Other members wishing to speak on the bill? Further amendments to the bill? Seeing none, the question now occurs on favorably reporting H.R. 2576 as amended to the House. All those in favor say aye. Aye. All those opposed say no. Opinion of chair, the ayes have it. Roll call vote is asked for. The clerk will call the roll.
Mr. Barton. Mr. Whitfield. Mr. Whitfield votes aye. Mr. Shimkus. Mr. Shimkus votes aye. Mr. Pitts. Mr. Walden. Mr. Walden votes aye. Mr. Murphy. Mr. Murphy votes aye. Mr. Burgess. Mr. Burgess votes aye. Ms. Blackburn. Mr. Scalise. Mr. Lotta. Mr. Lotta votes aye. Ms. McMorris-Rogers. Mr. Harper. Mr. Harper votes aye. Mr. Lance. Mr. Lance votes aye. Mr. Guthrie. Mr. Guthrie votes aye. Mr. Olson. Mr. Olson votes aye. Mr. McKinley. Mr. McKinley votes aye. Mr. Pompeo. Mr. Kinzinger. Mr. Kinzinger votes aye. Mr. Griffith. Mr. Griffith votes aye. Mr. Bilirakis. Mr. Bilirakis votes aye. Mr. Johnson. Mr. Johnson votes aye. Mr. Long. Mr. Long votes aye. Ms. Elmers. Mr. Bouchon. Mr. Bouchon votes aye. Mr. Flores.
Wait, the clerk will suspend. Mrs. Elmer, I heard Mrs. Elmer's.
Mrs. Elmers votes aye.
Yeah.
Mr. Flores. Mrs. Brooks. Mrs. Brooks votes aye. Mr. Mullen. Mr. Mullen votes aye. Mr. Hudson. Mr. Hudson votes aye. Mr. Collins. Mr. Collins votes aye. Mr. Kramer. Mr. Kramer votes aye. Mr. Pallone. Mr. Pallone votes aye. Mr. Rush. Ms. Eshoo. Okay. Ms. Eshoo abstains. Mr. Engel. Mr. Engel votes aye. Mr. Green. Mr. Green votes aye. Ms. DeGette. Ms. DeGette votes aye. Ms. Capps. Ms. Capps votes aye. Mr. Doyle. Mr. Doyle votes aye. Ms. Schakowsky. Ms. Schakowsky votes aye. Mr. Butterfield. Mr. Butterfield votes aye. Ms. Matsui. Ms. Matsui votes aye. Ms. Castor. Ms. Castor votes aye. Mr. Sarbanes. Mr. Sarbanes votes aye. Mr. McNerney. Mr. McNerney votes aye. Mr. Welch. Mr. Welch votes aye. Mr. Lujan. Mr. Lujan votes aye. Mr. Tonko. Mr. Tonko votes aye. Mr. Yarmouth. Mr. Yarmouth votes aye. Ms. Clark. Ms. Clark votes aye. Mr. Loebsack. Mr. Loebsack votes aye. Mr. Schrader. Mr. Schrader votes aye. Mr. Kennedy. Mr. Kennedy votes aye. Mr. Cardenas. Mr. Cardenas votes aye. Chairman Upton. Chairman Upton votes aye.
Other members wishing to cast a vote? Mr. Pitts?
Mr. Pitts votes aye.
Mr. Flores?
Mr. Flores votes aye.
Mr. Whitfield, did you vote? Other members wishing to cast a vote? Mr. Butterfield, did you vote? Did you? Mr. Butterfield reported. Other members wishing to cast a vote? Seeing none, the clerk will report the tally.
Mr. Chairman, on that vote, there were 47 ayes and 1 abstain.
47 ayes, 1 abstention. The bill is favorably reported, and technical changes will be made. The chair now calls up H.R. 2583 and asks the clerk to report.
H.R. 2583, to amend the Communications Act of 1934 to provide for greater transparency and efficiency in the procedures followed by the Federal Communications Commission and for other purposes.
Without objection, the first reading of the bill is dispensed with, and the bill will be open for amendment at any point. Are there any bipartisan amendments to the bill? Seeing none, are there any amendments to the bill? Gentlelady from California has the amendment at the desk.
Thank you, Mr. Chairman. I do have an amendment at the desk. It's DS-UB1-02.
I'm sorry, I couldn't hear you, ma'am.
I have an amendment at the desk. I believe it's DS-UB1-02.
Clerk will report the title of the amendment.
Amendment to H.R. 2583, offered by Ms. Eshoo and Mr. Pallone.
The amendment will be considered as read. The staff will distribute the amendment, and the gentlelady is recognized for 5 minutes in support.
Thank you, Mr. Chairman. Today I'm offering an amendment in the nature of a substitute which preserves our areas of bipartisan agreement on FCC process reform while excluding the provisions that would effectively tie the FCC in knots. The proposals offered in this amendment provide real transparency and accountability, not regulatory uncertainty or the potential excuse me, for legal challenges on every commission action. The substitute amendment preserves the FCC Process Reform Act with one exception. It ensures that implementation of the FCC Collaboration Act will occur at the same time as the other reforms included in the underlying bill. During last month's subcommittee legislative hearing and markup, not one substantive reason was given for delaying this much-needed reform, and all of the committee's witnesses supported its passage. My amendment also includes 3 bills which passed the subcommittee by voice vote on May 20th. As Chairman Walden described last month, Representative Lopsack's bill, quote, would allow the public to understand the up-to-now secret processes of the 8th floor. This is the kind of transparency that even the staff at the FCC will appreciate, unquote. Collectively, these 3 bills will help this FCC to be faster, more efficient, and transparent. A bipartisan vote of the committee is a win for a more transparent and accountable FCC, and I urge my colleagues to support the Democratic substitute and reject any partisan amendments that reduce the flexibility and efficiency of the FCC. So, in essence, this substitute amendment is a package of all of the bipartisan bills that have been offered. And it also eliminates the delay that's been placed in the what's really the Sunshine Law and or Act. We've been working on this now for 6 years, and you've been successful at delay. It's been delayed for 6 years. So why put a delay in it now? Again, nothing has been offered that explains any, the substance of why there should be a delay. All of the commissioners, Republicans and Democrats, are for it. Everyone that has testified has said the same thing. And so I think that this is a win to move forward on a bipartisan package. We both have different views of some of the other things that are being offered, but I think that on process reform, we should move ahead with a bipartisan package and get it done, and it'll be a feather in everyone's cap, and and it would be healthy for the FCC because there's really some real meat on the bones in terms of the legislation that's been offered on both sides of the aisle. So with that, Mr. Chairman, unless someone would like the rest of my time, I will yield back.
Gentlelady yields back,
I'm
or
sorry,
yields to the gentlelady
the
from New York.
gentleman from New York would like the remainder of time.
Thank you, Madam Ranking Member, and thank you to the Chairman. I'd like to thank my colleagues for offering this substitute amendment that combines the amendments offered by Mr. Loebsack, Ms. Matsui, and myself at the subcommittee markup. These amendments were supported by the subcommittee, and I ask that they be supported today at the full committee markup. The FCC oversees dynamic sectors that make up 1/6 of our national economy. Consequently, it's important for the government to understand and act quickly to keep up with the rapid innovation and shifts affecting these industries. The substitute offered today is smart and only adds in the transparency of the FCC. I fully support this amendment, and I ask my colleagues to do the same. With that, I yield back to the gentlelady, Ms. Eshue.
Gentlelady yields back. Other members wishing to speak on the amendment? The gentleman from good state of Oregon is recognized for 5.
I thank the chairman, and I thank my colleague and ranking member on the subcommittee for bringing these proposals forward, although I wish I was in a position to support them. Actually, the 3 bills we discussed in subcommittee and marked up, we actually had 6. And Republicans agreed to make the 3 the Democrats put forward as bipartisan bills. They're good reforms, just as we believe our bills are good reforms as well. I would take a different view of characterizing what my ranking member is proposing here as continuing a bipartisan process, because actually the underlying bill that she seeks to change is the very bill that we passed in subcommittee, full committee, and unanimously across the House floor last year and agreed to introduce intact this year until the day before the markup, when Ms. Eshue decided she's never liked the 1-year delay, I admit that, agree to that, and decided to move the amendment. And that really did kind of alter the agreement that we had negotiated last session, and I believed we had an agreement on this session as well. If we want to get into what the witnesses on the panels testified, I would concur. They did say that the 1-year delay from their perspective was not necessary. I'll get into why I believe it is. But then they also, 201, including the Democrats' witnesses, supported adding in cost-benefit analysis. By the way, the President of the United States has called for cost-benefit analysis to be used by agencies. This agency happens to be an independent agency, so his executive order does not apply. But if the gentlelady would like to agree with adding in cost benefits, as every witness testified, then we would be open to reconsidering the 1-year delay. The 1-year delay was put in there to give the FCC an opportunity to comply with the rest of the legislation designed to open up its process, allow the FCC to set various timelines and deadlines, and meet certain requirements. And if they did that, then they would have the opportunity to get what they seek most out of this, which is the ability to talk in private about matters of importance to the Commission. And so that's why we have a 1-year delay. We want them to actually comply with what Congress says. The FCC is littered with requirements to comply with statutory mandates that have gone unmet. And that is an issue that bothers me greatly and should bother every member of this committee, that this commission and its predecessor commissions have not complied with statute. And so if they want this additional ability to meet in private, then we think they should comply with the new requirements to make their processes more open and public. Now let me address the 3 Republican bills that we would offer as amendment today. One of them simply says that after the Federal Communications Commission votes on a rule, that within 24 hours of doing so, the text of that rule would be made available to the public. By the way, this is the public's business we're talking about here. Our amendments are right here. They've been filed 2 hours in advance. Substitute amendments are filed 24 hours in advance, I believe. We notice our hearings with a certain timeline in advance. We do our business in public. It is the public's business, and so is the federal communications business should be the public's business. It is. They need to be more transparent. So we say, if you pass a rule, just make what you pass public within 24 hours. You can do your explanations later, but link it on your website. We say if you're going to engage in matters on delegated authority to the employees as opposed to the commissioners, 48 hours ahead of that, you would make notice, again, a link to your website of something you already produce that just says, here's what we're going to take up 48 hours from now on delegated authority. That's onerous? Are you kidding me? And then we say on rules for circulation 3 weeks in advance, which is when they already share them internally, they make it public. We just went through this debate on net neutrality, and these reforms are not about net neutrality, but I think there's an example here that was reported in the trade press of various public interests who wanted to affect the decision-making of the FCC, which is their right, except they didn't know what the draft rules were going to be. They didn't know what was to be considered. Let me give you a prime example on the issue of interconnection. The chairman of the Federal Communications Commission, when he put forth his NPRM, did not have interconnection in it. He said publicly, I believe in July, it would not be part of the order. And at the end of the day, guess what? It was there. So if you're affected by this issue, you didn't know. In fact, you were told twice, in effect, that that issue wasn't even on the table, and yet in the end, it was in the rule. Is that really what my colleagues want to embrace? Secrecy, cloaked in star chamber activities, driven by a single person at times, regardless of party, who happens to chair the commission. We can do better than this. This legislation does. I reject my my colleague's amendment to the bill.
Gentleman's time has expired. Other members wishing to speak? Gentleman from New Jersey, recognized for 5 minutes.
Thank you, Mr. Chairman. I'd yield my time to Ms. Eshoo.
I appreciate the ranking member doing so. Mr. Chairman, I want to set the record straight. There have been reports suggesting that I pulled my support for the underlying FCC process reform bill because of the delay on the sunshine reform. It's simply not true. I've strongly disagreed with the inclusion of an artificial delay. Everyone knows that. It's been delayed for almost 3 Congresses now. And again, no one on the other side has ever offered anything substantive about why it should be delayed. I don't know what the reason is. No one ever says what the reason is. Now, the artificial delay of the FCC collaboration act is something, yes, I don't agree with it. I think it should move forward. But what I've offered is a compromise approach to enhance transparency and accountability at the FCC, and I've never wavered in that belief. Now, my decision not to co-sponsor 2583 came when I was informed that the majority would be offering its 3 partisan amendments at today's markup. Now, why would I co-sponsor a bill that I know will be reported out of the committee and sent to the House floor in a form that I can't support? So that's, I think it's just been, I think I've been absolutely clear on that. Suggesting that I reneged on a deal made in the last Congress, I think is really disingenuous and inaccurate. The subcommittee's passage of that bill by voice vote 2 weeks ago demonstrated that the Democrats continued to support the underlying bill while maintaining their objections to the 3 Republican bills that have the effect of tying the FCC in knots. In the previous Congress, I did. I let it go for the good of the order so that it would keep moving. And so we have a disagreement, and I still think that while we don't see eye to eye on some of the bills, that we can still move forward with a bipartisan package. Now, to throw in no, cost-benefit analysis and equate that with something else, and then the last Congress, I think it's just throwing a lot of sand in the gears. We're for reforms. Some of them we agree on, some of them we don't. But we do have consensus. We do have consensus on a package of bipartisan bills, and my choice is that we move forward on that. And so that's where I am. If colleagues would like to speak to this, I'd be happy to yield the remainder of my time. Seeing none, I
guess it's
yield.
my time, so
It's your time.
I'll yield back, Mr. Chairman.
Gentleman yields back. Other members wishing to speak on the amendment in the nature of a substitute? Seeing none, the vote occurs on the SU amendment. All those in favor will say aye.
Aye.
Those opposed say no. No. Opinion of the chair, the noes have it. Roll call vote is requested. The clerk will call the roll.
Mr. Barton, Mr. Whitfield, Mr. Shimkus, Mr. Pitts, Mr. Walden. Mr. Walden votes no. Mr. Murphy, Mr. Burgess. Mr. Burgess votes no. Mrs. Blackburn. Mrs. Blackburn votes no. Mr. Scalise. Mr. Lotta. Mr. Lotta votes no. Mrs. McMorris-Rogers. Mrs. McMorris-Rogers votes no. Mr. Harper. Mr. Harper votes no. Mr. Lance. Mr. Lance votes no. Mr. Guthrie. Mr. Guthrie votes no. Mr. Olson. Mr. Olson votes no. Mr. McKinley. Mr. McKinley votes no. Mr. Pompeo. Mr. Pompeo votes no. Mr. Kinzinger. Mr. Kinzinger votes no. Mr. Griffith. Mr. Griffith votes no. Mr. Bilirakis. Mr. Bilirakis votes no. Mr. Johnson. Mr. Johnson votes no. Mr. Long. Mrs. Elmers. Mrs. Elmers votes no. Mr. Bouchon. Mr. Bouchon votes no. Mr. Flores. Mrs. Brooks. Mrs. Brooks votes no. Mr. Mullen. Mr. Mullen votes no. Mr. Hudson. Mr. Hudson votes no. Mr. Collins. Mr. Collins votes no. Mr. Kramer. Mr. Kramer votes no. Mr. Pallone. Mr. Pallone votes aye. Mr. Rush. Miss Eshue. Miss Eshue votes aye. Mr. Engel. Mr. Engel votes aye. Mr. Green. Mr. Green votes aye. Ms. DeGette. Ms. DeGette votes aye. Ms. Capps. Ms. Capps votes aye. Mr. Doyle. Mr. Doyle votes aye. Ms. Schakowsky. Ms. Schakowsky votes aye. Mr. Butterfield. Mr. Butterfield votes aye. Ms. Matsui. Ms. Matsui votes aye. Ms. Castor. Ms. Castor votes aye. Mr. Sarbanes. Mr. Sarbanes votes aye. Mr. McNerney. Mr. McNerney votes aye. Mr. Welch. Mr. Welch votes aye. Mr. Lujan. Mr. Lujan votes aye. Mr. Tonko. Mr. Tonko votes aye. Mr. Yarmouth. Ms. Clark. Ms. Clark votes aye. Mr. Loebsack. Mr. Loebsack votes aye. Mr. Schrader. Mr. Kennedy. Mr. Kennedy votes aye. Mr. Cardenas. Mr. Cardenas votes aye. Chairman Upton.
Votes no. Other members
Upton
wishing to
votes no.
cast a vote? Mr. Shimkus.
Mr. Shimkus votes no.
Mr. Barton.
Mr. Barton votes no.
Dr. Murphy.
Dr. Murphy votes no.
Mr. Pitts.
Mr. Pitts votes no.
Mr. Long.
Mr. Long votes no.
Other members wishing to cast a vote? Seeing none, the clerk will call the roll, or the clerk will report the tally.
Mr. Chairman, on that vote, there were 20 ayes and 28 nays.
20 ayes, 28 nays. The amendment in the nature of a substitute is not agreed to. Chair would now call up an amendment under my name, but I would add Ms. Clark, Matsui, and Loebsack to the amendment. And the clerk will report the title of the amendment.
Amendment to H.R. 2583, offered by Mr. Upton, Ms. Clark, Ms. Matsui, and Mr. Loebsack.
And the amendment will be considered as read, and I'll recognize myself for 5 minutes in support of the amendment. I want to first congratulate or commend my 3 Democratic colleagues for their hard work on these amendments. We thought, as this bill moved through the subcommittee, that it would be a very good addition to the committee. And although we tweaked them just a bit, perhaps, I'm glad that they're still very supportive of what we're doing, and we think that it is a constructive addition to the amendment, which was why I wanted to include these as part of the bill. These amendments add their thoughtful and productive ideas that further our commitment to create a better functioning, more transparent FCC to this important bill. Their efforts demonstrate that members on both sides of the aisle understand the importance of reforming an agency that significantly affects the lives of everyday Americans. Complicated, sometimes secret processes have served as a barrier to small businesses who just want a seat at the table. This amendment incorporates these provisions, or the provisions offered by Representative Matsui, that encourages the Commission to engage with small businesses as well as recommend legislation so that we can do our job as lawmakers to make sure that small businesses are not shut out at the FCC proceedings. The amendment also requires the publication of any policies related to the functioning of the Commission itself. Even the soundest policies and procedures serve no purpose if they aren't clear for those affected. And clear publication of the FCC's internal rules, as originally offered by Representative Loebsack, enhances in understanding and promotes participation in the work of the Commission. Finally, this amendment includes provisions proposed by Representative Clark that enhance the public's ability to review the Commission's progress on petitions, applications, and complaints by requiring the reporting of pending matters before the committee. Our goal is to spur the Commission to increase its efficiency in handling the public's interest. Request for action, transparency to the public furthers that goal. So these reforms do have an important place in this bill. I want to thank them for their hard work, and we were glad to include this, and would urge my colleagues to support the amendment.
Would the gentleman yield?
Would yield to the gentleman from Oregon.
Yeah, I'll make it quick. I too want to commend my colleagues on the other side of the aisle for bringing these forward. As you can see, in a bipartisan way, not only did we support them in subcommittee, we worked with our colleagues to address some issues that have been brought to our attention in a bipartisan way, and plan to include them in the underlying bill. I think also, if you look at the new requirements that these three provisions put on the FCC, and some could make an argument that they actually exceed what we're requiring with the three pieces of legislation we'll bring forward from our side of the aisle. Because I think in nearly every case, the three Republican amendments that we will consider later simply require the FCC to link what they already produced to their website. And so for the most part, the documents are already there, and what they do is already done. We're just making it more public. And so I thank my colleagues on the other side of the aisle, look forward to continue to work with them as together we try and improve the processes at the FCC and open it up and make it a more transparent public body. With that, I yield back, Chairman.
Gentleman yields back. Other members wishing to speak on the amendment? If not, the vote occurs on the amendment offered by the four members of the committee. Those in favor will say aye. Aye. Those opposed say no. Opinion of the chair, the ayes have it. The amendment is agreed to. Other further amendments to the bill? Mr. Sarbanes has an amendment to the bill. The clerk will report the title.
The title is Yarmouth.
Oh, I'm sorry. Mr. Sarbanes is offering Mr. Yarmouth's amendment.
Amendment to H.R. 2583, offered by Mr. Yarmouth, Mr. Pallone, Ms. Eshoo, Mr. Butterfield, Mr. Green, Ms. Matsui, Mr. Sarbanes, Mr. Welch, and Ms. Clark.
And well, the amendment will be considered as read, and the gentleman from Maryland is given 5 minutes to speak in support of the amendment.
Thank you, Mr. Chairman. I want to thank Mr. Yarmouth for authoring this important amendment. I appreciate the opportunity to present it to the committee. The topic of today's markup is all about transparency, as you've heard from a number of members, but there's one area where transparency is seriously lacking right now, and that's with respect to the disclosure of political ad donors. Millions of dollars, we've seen this over the last few cycles, are being funneled into issue advertisements that are designed to sway the American public on specific candidates and on other important political issues. In fact, the amount of political spending by organizations that don't disclose their donors at all has grown tremendously. Back in, 6 years before, in 2006, these groups spent $5.2 million. Within 6 years, in 2012, that had increased to $300 million. And there's millions more spent on advertisements where we don't know who the donors are behind those advertisements. The FEC currently has the authority under the Communications Act to require on-air disclosure of the, quote, true identity, end quote, of the people and groups buying ads. But unfortunately today, mega donors hide behind innocuous and misleading titles of these groups that are sort of fronting these political advertisements. The amendment before us, the Yarmouth Amendment, would require disclosure of the donors behind super PACs and 501c4 organizations that are flooding the nation's airwaves with anonymous ads. It directs the FCC to use the agency's existing authority in the Communications Act and update the sponsorship identification rules before the 2016 election season. In particular, it would say that when somebody steps into discussion of political matter, a matter involving the discussion of a controversial issue of public importance, that announcement or advertisement shall include the names of significant donors that are behind that particular expenditure. Mr. Chairman, the average American out there is deeply, deeply cynical about politics these days, and a lot of it has to do with this, these hidden donors that are putting tremendous amounts of money behind these advertisements. It's led to this cynicism, this lack of faith, and Americans fundamentally just want to know who is behind these advertisements. If you think about it, when they go to a town hall to talk or testify on a zoning ordinance or something, they have to sign in, they have to put their name, they have to stand up and show who they are. But yet these people that are spending millions of dollars are completely hidden from public view. And if they're going to spend significantly, they ought to disclose who they are. They don't have to participate in the process. They don't have to step out and enter the political arena. But if they do it, they should indicate who they are. They should step forward and present who they are. Americans want to see this disclosure. They want to see this transparency. And it's important to do that if we're going to restore some faith. And no less a protector of our democracy than Mitch McConnell has talked at length about transparency and disclosure. He hasn't done it recently, but in 1997, Senator McConnell said, quote, "I think disclosure is the best disinfectant." I agree. He also said, "Public disclosure of contributions and spending should be expedited so voters can judge for themselves what is appropriate. These are reforms which respect the Constitution and would enhance our democracy." And in 2001, he said, what we ought to have is disclosure. I agree with that. We need disclosure, we need transparency, we need to know who these donors are behind these commercials, these advertisements. If we do that, if we pass an amendment like this one, which is a common sense amendment, it will demonstrate that we have respect for the American people and perhaps begin to restore some faith and confidence in the political process, which is sorely needed these days. And with that, I yield back my time. I urge the committee to adopt this Yarmouth Amendment.
Gentleman yields back. Gentleman from Oregon is recognized for 5 minutes.
Thank you, Mr. Chairman, and I appreciate the gentleman's amendment and his discussion about transparency, which we'd like in this bill to first apply to the Federal Communications Commission itself, which is the underlying issue here, not necessarily campaign finance reform. But since he's brought his amendment, I'd like to raise a few issues that I think are important for consideration. First of all, in the amendment, you do not determine who would decide what a controversial issue is of public importance. Ultimately, it would fall on the individual broadcaster to make that decision, we believe. It is not defined. It raises First Amendment issues and therefore constitutional issues about how this would be applied, who would determine what a controversial issue is of public importance. Second, there is no definition of what the names of significant donors to the person means. And that is an issue. If you have a city council race where you raise $10,000 from $1,000 from each person, then each person, I would assume, would be a significant donor. And therefore, within the disclaimer ad, you'd have to list the names of all of those individuals. And you can imagine, as you apply this on across larger races and up to congressional races and all, that suddenly your ad wouldn't be long enough to list all the donors that someone might consider to be significant, and because significance not defined, that's a problem. Now, the other piece I'd like to raise is certainly one, and while I'm not a lawyer, I know many on the committee are, and that's the Loveday case that from 1983 in the D.C. Circuit, where this issue in part was addressed in terms of trying to figure out the true sponsor. And what the court said there was that, and I'll quote, even supposing a searching investigation to be a realistic possibility, the result of requiring it would be an administrative quagmire. Broadcasters differ greatly in their resources and personnel, ranging from large stations in suburban areas to small stations that often have no more than one person on the premises. Similarly, the sponsors whom they would have to investigate may be large or small, nearby or geographically remote, cooperative or recalcitrant. And as you may remember in the WJLA case, they basically rejected this as impossible to do. So I think, while disclosure is a good thing, and I was in that business, and we had to keep files, and we had to disclose, the disclosure really takes place over in the Federal Elections Commission and other places, and if this is put on broadcasters, cablecasters, others who would be under the FCC's regulation, it seems to, by many measures, present constitutional freedom of speech issues. It presents, as the court said, a quagmire of administrative issues, and potentially could result in ads that would have nothing more than disclosure of sponsors' names, which would really be meaningless. Beyond all that, the media world's changed. In 2016, online political spending topped almost $1 billion for the first time, surpassing newspapers, direct mail, and telemarketing. So what it would mean is you just shift the money somewhere else. Freedom of speech matters, disclosure matters, but I think this amendment is not well perfected, and therefore I would urge opposition. And
Gentlemen, yield.
Restore the, sure.
I mean, I understand your concerns and the points that you've raised. I have a fair amount of confidence that the FCC, based on its experience in these matters of advertisement, would be able to come up with standards that are sensible to avoid the kind of administrative quagmire that you just referred to. And I think that the public would probably respond to what you said by saying, well, let's try and do this and see if we can make progress with it.
Reclaiming my time, this Loveday case was involving the Federal Communications Commission in 1983, so we've been down that path, and the D.C. Circuit came back and said this really is not workable in what was being proposed. There are other places where money is disclosed, as you know. There are other places where it's not disclosed as fully as you would like and others would like. But clearly this amendment, as crafted, presents both constitutional freedom of speech issues as well as creating undue burdens that the court in Loveday has already said are a problem that likely could cause major additional problems. So with that, my time's expired.
Gentleman's time has expired. Just the gentleman from Kentucky, Mr. Yarmouth, since it's his amendment, let me just jump the others who had their hand up.
Thank you, Mr. Chairman. I move to strike the last word.
Recognized.
First of all, let me thank Mr. Sarbanes for presenting this. I was sitting in the ranking chair at Budget, keeping a hearing going, so I appreciate that very much. When we talked about this in subcommittee, I know a lot of people on our side said if you're concerned about transparency, as Republicans' initiative would indicate that we ought to be concerned about transparency as to campaigns. And I thought about that a lot, and I said, you know, I intend to vote for the final measure here. I know a lot of my colleagues on our side won't, because I think if we're asking you to take a more expansive look at transparency, that I ought to be willing to do that as well. So I intend to do that. But I think what we have here is an opportunity to really change public attitudes about elections. And there was a poll released yesterday, New York Times poll, 75% of Americans think that donors to these, people paying for these ads ought to be disclosed, equal numbers of Republicans and Democrats. There is no party divide in terms of the public as to what should be done. As a matter of fact, 72% of the people in the poll said we ought to be limiting contributions. So what we're suggesting now, what this amendment suggests is, do what the majority opinion in Citizens United suggested. Make sure that the public knows through full disclosure who's spending huge money to influence elections. And that was kind of the precondition. If you read the majority report, that's what they said makes that possible. If we're going to allow unlimited contributions, it's fine as long as the people know who is making them, whose money it is. That's what this amendment does. It basically says the FCC has the authority to require disclosure of any of these groups who are running ads on television, and they should use that authority to require disclosure. Again, broad support among the American people. This is what the Citizens United's decision suggested. Even my Senator Mitch McConnell, over the years, has said, you know, and obviously he is not a champion of limiting campaign contributions, but he has said until recently, but going back 40 years, that what makes this possible is complete, thorough disclosure. And that's what we ought to be doing. This is one mechanism the federal government has to make sure that the American people is fully informed about those who are trying to convince them, manipulate them, lobby them, whatever word you want to use. And I think it's very, very critical that, again, we take this opportunity to help restore credibility of our elections with the American people. And I would urge my colleagues to support this amendment.
The gentleman yield?
I will yield to the ranking member, yes.
I just wanted to urge support for the Sarbanes-Yarmouth amendment, and also commend both of you, because I know that this isn't the only time that the two of you have been out there talking, you know, responding to Citizens United, talking about the need for transparency and disclosure, and I see no reason why this couldn't be included today with this FCC bill, since again it's talking about the FCC and disclosure. I'm a little concerned about the suggestion by Mr. Weldon. I understand what he's saying, but that somehow this is a violation of the First Amendment. It seems to me that, you know, any type of disclosure or limitation, if you will, that involves disclosure, if you want to even see it as a limitation, I don't see that violating the First Amendment. It seems to me that when you talk about free speech, that those who are making the speeches shouldn't have, or, you know, you exercising the right to free speech shouldn't be in any way worried about the fact that they have to acknowledge that they're doing it. So to me, this is the proper place really to have this kind of amendment introduced and added to the bill that we're moving today. And again, I can't say enough about how, you know, the way that money is corrupting the system, and I think one way of limiting that corruption, if you will, is by making people responsible for what ads they're putting up and what money they're spending. I don't see it in any way as an infringement on the First Amendment.
Would the gentleman yield?
Well, it's not my time. I yield back the time that to the gentleman.
Yeah, if you just on that point, it's not the speech itself. It is who it is that you would ask somebody to determine what is or is not a controversial issue, or whatever the language was here, a controversial issue of public importance. That's where I think the constitutional question comes up. It is who determines that. Is it a small market radio station out in rural Oregon, or a TV station in New York City? Or that's where the burden would rest.
Gentleman's time from Kentucky has expired. Other members wishing to speak on the amendment? Gentleman from Vermont is recognized.
I appreciate this amendment. You know, and I appreciate the comments that Mr. Walden made. There's constitutional issues, there's legal issues, there's practical issues. But I think all of us know, every single one of us in this committee and every single one of us in Congress knows that as much as we may have a relationship with the people in our district that we represent, people are just disgusted with this institution. It's not working. And money is a big problem, and there's not an easy solution to it. But the steady as she goes is not going to work. I mean, when you think about this Congress not even being able to pass a transportation bill, you know, and it's not on you, it's not on us, really it's on all of us, arguing about the details about how perfectly this is designed or what some of the practical issues are is just rearranging the deck chairs on the Titanic. So this is one opportunity for us to make a modest statement that we get it, that money's killing us. We look at our presidential candidates, and the first round of effort is to go to the billionaires that are going to support them. You know, there's a place for billionaires. They've been successful. But all of us know in our hearts that the poll numbers that the American people express their discontent with this institution have a real basis. And we've got to start responding to that somehow, some way, and we've got to do it together. So I see this amendment by Mr. Yarmouth and Mr. Sarbanes is at least a modest acknowledgement that we've got to try to address this problem that is, I think, corroding the institution that we represent, and try to start taking steps towards taking money out of politics and putting people back into it.
Gentleman yields back. Other members wishing to speak on the amendment? Gentleman from California first.
Thank you, Mr. Chairman. I want to thank Mr. Yarmouth for the work that he's done on this, and to the members on this side of the aisle for the bills that they've offered. They've worked hard, they thought long and hard about it, and I think that their work is being recognized, and I thank them for it. On this issue, you know, the operative word for the last several months has been transparency. Transparency. What does the word mean? It means that you can see through something, that everyone can see through it. We're not a private corporation. We're not a board of directors here. We're public officials representing the public collectively across the country. And within this institution are the tools of democracy. This isn't just about yin and yang. This strikes at the heart of democracy. And if those that are governed do not trust those that are governing, our country is in trouble. The reason we have the broadest, deepest markets in the world turns on the coin of the realm of confidence that we are a safe place to invest. And yet the confidence of the American people does not ride with this institution. And it's for several reasons. And this subject is one of them. Anyone that says, we believe in transparency, but not here, that is, I can't help but think of Shakespeare. Thou doth protest too much. This is wrong, we can't do this. Constitution, the FCC, people won't know, or they will know, or it's cumbersome. You know what? That's on every piece of legislation. We always have to work hard at working out the details. That isn't anything new. We always have to work to make bills meet those high standards as we move along. This isn't the first time that we're challenged by this. But I think that the American people are on the right side of history on this, and that is these unreported, unknown donors with unknown sums of money belong to a banana republic and not the United States of America and our system. So to upgrade this, we know, A, that the FCC has the authority to do so. Number two, that it would help to regain the confidence that the American people should have in their elections. We send monitors all over the world to monitor other countries' elections to make sure that they are sound and democratic. Look at our own. It's not defensible. It simply is not defensible. This has nothing to do with the amounts of money. The FCC doesn't have any authority over that. This is simply the reporting and making transparent and public who actually paid for the ad. Is that too much for our system to bear? And then at the same time say we're for transparency for something else, but we're not transparent when it comes to the essence of democracy? These ads are part of elections. Candidates spend more money on advertisements than they do on any other part of their campaign budget. The public knows this. The public is turned off by it. And we're saying, as we're considering FCC reforms, that this belongs in it. I think that my party is on the right side of history on this one. I think we're on the right side of history. I know we're on the side of the American people on this. That is abundantly clear. So I thank the gentleman for offering this. It's extraordinarily critical, and I yield back.
Gentlelady's time has expired. Other members, gentleman from New Mexico.
Thank you very much, Mr. Chairman. And again, thank you, Mr. Yarmouth, for the work that he's doing here, and Mr. Sarbanes for the attention that he always brings with the pulse to the country. But what Mr. Yarmouth is doing is something that's pretty simple, and all it does is it ensures that every American knows who's really behind all the ad spending during every election. It seems like common sense to me, right? I mean, we talk about making sure that everyone knows what's happening, real transparency. As we talk about a common sense approach and something that should be embraced by the American people, and as Mr. Yarmouth pointed out, the New York Times article that covered a poll that showed 75% of the American people support significant reforms to reporting, to transparency, to disclosure when it comes to money in campaigns. And what I don't understand is, as this debate ensues, already anybody who donates more than $200 to a single candidate, party, or PAC already has to disclose who they are, something that millions of Americans already do. And asking the FCC to list who is buying ad time to influence the election is somehow a heavy burden through reporting. That's not, and to suggest that's not consistent with free speech, well, the American people don't seem to agree. And if there's a concern with some of the definitions or the approach, this is a place that we should be able to work together. Because in the end, this can be listed on the FCC's website as the legislation is asking for. And the last time that I checked, if you go to
Would the gentleman yield?
I will in a moment,
That's
Mr. Walton.
not what the amendment does.
Well, I think that as we talk about this, Mr. Chairman, there might be a way for us to work through this if there's agreement to maybe address this in a different fashion as we go to the floor. But the last time that I checked, and if you go to a local radio station or if you go to a local broadcaster, they have information there that says who bought the TV time, right? You can go check who bought commercials, and if it's during campaign season, that's available. What's not included is just the additional reporting mechanism of how and where that money is coming from. So as we look at how we might be able to make this better, and I think that that's what legislating and compromise is all about,
If there's some language that we agree with, but maybe those principles are a little bit off, or the definitions are a little bit off from where both sides can find common ground, let's work to get it done. And maybe there's a way to get this done before we go to the floor, as we're hearing some of the opposition here with the amendment today. And I would just say, Mr. Chairman, that just imagine for a moment how powerful this would be. Every American who wants to know about where this money is coming from could go to one place. And my recommendation as we continue to look at this, as I brought up during the subcommittee markup on this, maybe the FCC's website. That would be real transparency in action as we talk about a central location. And Mr. Chairman, just to be clear on this, we should be using every tool possible, whether it's with the FCC with reporting who's buying this and where the money's coming from, or through any other federal agency that we can work with to make sure full disclosure is truly transparent. So I hope, Mr. Chairman, that my colleagues will support Mr. Yarmouth's proposal to restore accountability to our electoral system and transparency to the American people. And with that, if none of my colleagues need time, I will yield back the ballot. I would yield to Mr. Walden.
Well, I would just say, and I appreciate what the gentleman's saying, but that's not what the amendment calls for. It didn't call for that in sub or now in full. It is it is like, and we both run the campaign committees, right?
Yes.
So this is, instead of saying paid for by the DCCC, it would say paid for by the DCCC and then list the names of significant donors. Now, I want you tell me, I can't tell you how many significant donors we have, but it's a lot. Not as many as you because you outraised us by $60 million, but that's another story. We got better rate of return. But my point is there's some mechanic. I know who you're trying to go after. I get the title of the bill. I do. But this isn't about listing on a website or in the public file.
Mr. Chairman, reclaiming my time because it's going to run out here. The reason that we had more donors is because our average was a lot lower than yours from people across the country. But
So
with
our
that being
disclaimer
said,
would be
with that being
longer.
said, Mr. Chairman, if we could, maybe this is an area that you and I could work together with the chairman with the idea that I'm suggesting, so that way it doesn't show up on the commercial. Let's work to make sure there's full disclosure reporting with the money behind it, and we'll get it on the FCC's website. Clearly, there's room there. And so I'd be happy to work with you and the staff.
Gentleman's time has
Take the
expired.
time.
I would note that if the two gentlemen can work something out together that they agree to, I look forward to having that as an amendment on the House floor, and I will let you do that in the next number of days. We've debated this for about 25 minutes, and I'd like to get to conclusion here, but I'll recognize the gentlelady from Florida to strike the last word.
Well, thank you, Mr. Chairman. I wanted to speak in favor strongly of the Yarmouth and Sarbanes amendment and thank them for their leadership. This isn't something that they just devised today. They have devoted a substantial amount of time since the Citizens United Supreme Court decision to bringing transparency to our election process. What a travesty that Citizens United Supreme Court decision was. What it said, in essence, is that Americans with the most cash have the loudest voices in our elections. That's dangerous for our democracy. Now the fattest wallets have more influence. People with the fattest wallets have more influence. It invites corruption. We need to address this. Now, many of you don't know that the gentleman who flew the gyrocopter onto the Capitol grounds was a gentleman from my district back home. I do not suggest that anyone do this. In fact, do not do it. It is very dangerous. Do not do that. But do you see how desperate the American people have become for the Congress to address this matter? We know how to do this. The fact that you say that the FCC couldn't handle this, that's ridiculous. There are many high-priced media consultants that know very well how to put disclaimers onto political ads, to have voiceovers to explain who is paying for that political ad. We should not allow these super PACs to go unrecognized. Who's funding them? People want to know. Americans need to know who's behind certain candidates and certain causes. That's what democracy is all about. I invite you all to go back and read Justice Breyer's dissenting opinion in Citizens United, where he, in essence, said that he noted the appearance of corruption to Americans so disillusioned by the influence of money and politics and government further erodes our democracy. We have got to address this, and the fact that we don't have a constitutional amendment on the horizon, we don't have a change in the United States Supreme Court makeup on the horizon, makes this legislative effort all the more important. So I salute my colleagues, Congressman Yarmouth, Congressman Sarbanes, all of you who have supported campaign finance reform. This is a very modest but important step to promote disclosure of big money, who's funding our elections in the United States of America. I urge the adoption of the amendment.
Will the gentlewoman yield?
And I yield the balance of my time to Mr.
I appreciate that very much. Just one comment about the logistics of implementing the amendment were it to pass. I fully expect that the FCC would say that disclosure would be required of people who paid more than a certain percentage of the ad, for instance. I mean, there are standards that could be set so that you wouldn't obviously result in the scenario that Mr. Walden suggested, where the DCCC and the RCCC would have to, RNCC would have to do publish all their donors or their large donors. I think there are ways that the FCC would implement this that would be very reasonable. Would say if somebody's paying 50% of the cost of the ad, then they have to be listed. But there are ways to do that. We don't prescribe that. We assume that the FCC would take that into consideration in adopting the policy. I yield back.
I'll yield to Mr. Sarbanes.
Mr. Chairman, this is just 10 seconds, but I would just observe that it's not good enough for us to say that this is too hard, it's too complicated, it's too difficult to do. We should be able to find a way to make this work so that disclosure and transparency is there. If we care about restoring faith in our government, in our politics, addressing the deep cynicism that's out there, we got to work hard to make that happen, and this would be a first step. Thank you, Mr. Yarmouth, for introducing this.
Gentlelady yields back. Other members wishing to speak? Seeing none, the vote occurs on the amendment offered by Mr. Yarmouth by Mr. Sarbanes. Those in favor will say aye. Aye. Those opposed say no. No. Opinion of chair. The ayes have it, so a recorded vote or a roll call vote is requested. Yes. The clerk will call the roll.
Mr. Barton. Mr. Whitfield. Mr. Shimkus. Mr. Shimkus votes no. Mr. Pitts. Mr. Pitts votes no. Mr. Walden. Mr. Walden votes no. Mr. Murphy. Mr. Murphy votes no. Mr. Burgess. Mr. Burgess votes no. Mrs. Blackburn. Mr. Scalise. Mr. Lotta. Mrs. McMorris Rogers. Mr. Harper. Mr. Harper votes no. Mr. Lance. Mr. Lance votes no. Mr. Guthrie. Mr. Guthrie votes no. Mr. Olson. Mr. McKinley. Mr. McKinley votes no. Mr. Pompeo. Mr. Pompeo votes no. Mr. Kinzinger. Mr. Kinzinger votes no. Mr. Griffith. Mr. Griffith votes no. Mr. Bilirakis. Mr. Bilirakis votes no. Mr. Johnson. Mr. Johnson votes no. Mr. Long. Mr. Long votes no. Mrs. Elmers. Mrs. Elmers votes no. Mr. Bouchon. Mr. Bouchon votes no. Mr. Flores. Mr. Flores votes no. Mrs. Brooks. Mrs. Brooks votes no. Mr. Mullen. Mr. Mullen votes no. Mr. Hudson. Mr. Hudson votes no. Mr. Collins. Mr. Collins votes no. Mr. Kramer. Mr. Kramer votes no. Mr. Pallone. Mr. Pallone votes aye. Mr. Rush. Miss Eshue. Miss Eshue votes aye. Mr. Engel. Mr. Engel votes aye. Mr. Green. Ms. DeGette. Ms. DeGette votes aye. Ms. Capps. Ms. Capps votes aye. Mr. Doyle. Mr. Doyle votes aye. Ms. Schakowsky. Ms. Schakowsky votes aye. Mr. Butterfield. Mr. Butterfield votes aye. Ms. Matsui. Ms. Matsui votes aye. Ms. Castor. Ms. Castor votes aye. Mr. Sarbanes. Mr. Sarbanes votes aye. Mr. McNerney. Mr. McNerney votes aye. Mr. Welch. Mr. Welch votes aye. Mr. Lujan. Mr. Lujan votes aye. Mr. Tonko. Mr. Tonko votes aye. Mr. Yarmouth. Mr. Yarmouth votes aye. Mrs. Clark. Ms. Clark votes aye. Mr. Loebsack. Mr. Loebsack votes aye. Mr. Schrader. Mr. Schrader votes aye. Mr. Kennedy. Mr. Kennedy votes aye. Mr. Cardenas. Mr. Cardenas votes aye. Chairman Upton.
Votes no.
Chairman Upton
Members
votes no.
wishing to cast vote, Ms. McMorris Rogers.
Mrs. McMorris Rogers votes no.
Mr. Latta.
Mr. Lotta votes no.
Mr. Barton.
Mr. Barton votes no.
Mr. Olson.
Mr. Olson votes no.
Mr. Kramer, are you recorded? Other members wishing to cast a vote? I'm sorry, Mr. Green?
Mr. Green votes aye.
Other members? Seeing none, clerk will report the tally. Who? Elmers? She's recorded. Is Mrs. Elmers recorded? She is, okay. Keep going.
Mr. Chairman, on that vote, there were 22 ayes and 28 nays.
22 ayes, 28 nays. The vote, or the amendment, is not agreed to. Other members offered an amendment to the bill. Mr. Gentleman from Illinois, Mr. Kinzinger.
Mr. Chairman, I have an amendment at the desk.
Clerk will report the title of the amendment.
Amendment to H.R. 2583, offered by Mr. Kinzinger.
Amendment will be considered as read. Staff will distribute the amendment, and the gentleman is recognized for 5 minutes in support of his amendment.
Oh, thank you, Mr. Chairman. I'd like to offer this amendment based on a bill I introduced with Congressman Allen, H.R. 2592, that would require the FCC to publish the draft of any item that's circulating on a vote at the Commission. The goal of this bill is to require the FCC to allow the public better access to its rulemaking. As things stand right now, only those companies or individuals fortunate enough to employ or hire lobbyists have access to the Commission's thinking during a critical phase of the rulemaking. This is when the last arguments can be made. This is when the last analysis of how these rules can impact your small business is done. Instead of allowing the chairman to pick and choose who can access this information, or worse, allowing only the companies who can afford to pay to access the information, this amendment would allow anyone access to the draft order. Given the effort of the chairman and myself over the past few years to reform other processes at the FCC, I believe this legislation rightly belongs in the larger overall package of FCC reforms being discussed. I've heard some of the critics of my bill argue that this change to FCC procedures would result in endless rounds of comments, but we've talked to the experts in administrative law, and they simply don't believe this to be true. The draft order doesn't give anyone the right to appeal because the draft order is not binding or final. No one's rights are modified by a draft order. Moreover, publication of a draft order may generate new comments in ex parte meetings, but these comments can be handled during the FCC sunshine period. And if by chance something comes up that's so new and so significant that the FCC has to address the issue, then I think it makes sense at the FCC to stop and rethink the course of its decision. At this point, I'd also like to thank Public Knowledge for lending their help to ensure that the changes made by this amendment will, with all clarity, not create any new procedural rights within the publication of drafts. Additionally, we've already marked up the language for this amendment at subcommittee to address concerns raised by critics. I believe we've shown that we're open to making this idea better so that we can all support the notion that all American people should have access to the FCC rules that impact all of our lives. I wish I could say that my Democratic colleagues have been equally forthcoming. What I have heard is that they oppose the concept and have offered no path forward. Let me say that again. They oppose the American people's right to see for themselves how the FCC's rules and regulations will be changing their lives. This amendment would change that, and I hope you can support the rights of citizens to see clearly what their government is doing. With that, I'll either yield back or yield to my side that needs time. And I'll yield.
Gentleman yields back. Gentlelady from California is recognized.
Thank you, Mr. Chairman. I think everyone here agrees that members on both sides of the aisle have worked hard on the amendments that they wish to offer, and that we have differing opinions about them. And I don't think that's bad. I think that it's fair, and some we agree on, some we don't. But I think it's a mischaracterization to say that one side wears Robin Hood's hat and the other side wears no hat or whatever. I don't know. I don't get that one. But at any rate, I move to strike the last word. I do thank the gentleman from Illinois for his attempt to improve FCC accountability and transparency. Unfortunately, this amendment will not help the FCC make decisions faster, more efficient, or provide meaningful transparency. In fact, the amendment potentially creates a never-ending cycle of lobbying where stakeholders have no incentive to participate in the rulemaking process until the last minute. The amendment could have also have the perverse effect of undercutting the ability of the 4 FCC commissioners to have an input on FCC orders. As Professor Stuart Benjamin testified last month, quote, "The point at which commissioners review proposed rules and suggest changes would be the point at which such changes would become more difficult to make. This is, I think, a recipe for less meaningful review by other commissioners," unquote. Let's be clear about what this particular bill is really about. The majority doesn't like the outcome of the FCC's net neutrality decision, and they will use every tool they can to bring the agency to a standstill. All you have to do is look no further than the January 22nd letter from Chairman Upton, Walden, and Thune to Chairman Wheeler, which asked that the draft order be released before the other commissioners had an opportunity to review it. Let me say that again. Asking that the draft order be released before the other commissioners had an opportunity to review it. Now, 3 months later, this bill was put forward for discussion by the subcommittee. I don't think this makes things work any better at all. I respect the author of it, but I stand in opposition to it. I just think that this is, it's like an arrow that's pointed at the heart of 4 commissioners not being able to study and respond. And how is that commission going to function? Would you do the same thing to this committee and our process? I don't think so. So this is, I don't think this is worthy of our support, and I urge members to oppose it. Thank you, and yield back.
Mr. Chairman.
Gentleman from Oregon.
Thank you, Mr. Chairman. First of all, I want to ask council a question. Is there underlying existing law that would prevent the so-called cycle of never-ending cycle of comment?
The changes that this amendment would make would only permit folks to continue to comment. There's 2 ways to comment the FCC. One is through ex parte commentary. The other is through notice and comment rulemaking. The changes in the amendment would not trigger further notice and comment rulemaking, and it would not change the ability of outside parties to continue ex parte commentary during the non-sunshine period.
So this would not trigger an endless cycle of comment as referenced?
That is correct.
So, Mr. Chairman, I would just say I disagree with my friend from California on a couple of points, obviously. One is we're not the first to ask for this. Actually, the former chairman and then ranking member, Mr. Dingell, asked for disclosure. Also, one Barack Obama, when he was senator, asked for disclosure when it came to the media ownership rules. They asked for the same thing. We had some really good testimony before the committee from the commissioners themselves and others, and we've read the stories where you don't know what the final rule is going to contain, and we're not asking for the final rule. We're saying when this is put out 3 weeks before, put it out to the public. Again, I get back to, and somebody can correct me if I'm wrong, but there was this notion that the issue of interconnection was not going to be part of the net neutrality rules. It was not in the original NPRM. The chairman indicated that this was not going to be part of it, and then in the end, it ended up in the rules. And so people didn't have, the public, the people, that's who we serve, did not have an opportunity to know what was even before them. We don't operate that way in this committee, nor should we. We've tried to change how Congress operates. I chaired the transition so that we could at least, when my party took control of the House, and we changed House rules and procedures and protocols so that bills are posted online, and we haven't been perfect, but we've tried to move forward on openness and transparency of the public's business. The legislation proposed by Mr. Kinzinger, first of all, is not an additional burden of any significance on the commission, but it is a positive step forward for the public, because it says now you can see what we're going to work on in our final period here. And you know what? The commission may learn something from that. If I recall the testimony correctly, and maybe I'll go to counsel, isn't it true that the commissioners, by practice at the commission, cannot discuss with somebody who comes in what's actually in the order under consideration?
That's correct.
So you, as a member of the public, come into the commission and say, I'm really concerned about what I'm hearing, and the commissioner you're talking to can't tell you, well, that's not in the order, or they're not supposed to tell you that's not in the order. And the commissioners cannot make what they are considering public. Is that correct?
Not without the permission of the chairman.
So the chairman himself or herself decides solely what the public knows or doesn't know. Now, can outside paid lobbyists, whatever you want to call them, people come in and meet with the commissioner and have a robust discussion about what the document may or may not include?
In practice, when an item is put on circulation, everyone with stake in the game tries to get a meeting with commissioners in the chairman's office to get their changes made.
But the
without
chairman
knowledge
has
of
the,
what's
but doesn't the chairman have the flexibility to determine how far that conversation goes, unlike the other commissioners?
Yes, the chairman is solely in charge of how much information the FCC releases.
So this is where we can do better. This is where we can do better. There was a reference made earlier about a banana republic. We can fix this problem. I yield to Mr. Kinzinger.
Well, I thank you for yielding. I just want to make the point, and again, I respect everybody's opinion on this, appreciate the conversation. Now, there's all this talk about this being, you know, I guess, sour grapes on net neutrality. And I just remind, as we talked about in subcommittee, Mr. Walden, you and I have had this conversation long before net neutrality was even a player. And, you know, just the reality of making things more available, more visual, more out there for people to have input, I think makes complete sense to what we're trying to do here. And so, you know, I'll, of course, be asking for a recorded vote on this because I think everybody ought to own whether or not, you know, they believe in this level of transparency with the FCC. So I thank the gentleman for yielding. I'll yield back his 15 seconds.
And I'll yield back balance.
Gentleman yields back. Other members wishing to speak? Gentleman from Vermont is recognized.
On transparency, I think there's two issues. One is the publication and timeliness of doing that. The other is the explanation that is offered in, substantively to explain the basis of the decision. And this amendment would have every decision announced within a day. And that's in some ways a good thing. And as I understand it, the FCC...
Would the gentleman yield? That's the next amendment.
Well, this has to be published within 24 hours. Oh, that's Elmer's. Okay, I'll withdraw.
That is coming.
Yeah, okay.
But that's the next one.
Then I'll be patient.
Gentleman yields back, and the chair would recognize the gentleman from New York, Mr. Engel.
Thank you. I'd like to yield my time to Ms. Eshu.
Which one is?
I thank the gentleman. I'd like to ask counsel about the following. When I spoke about the potential for creating a never-ending cycle of lobbying where stakeholders have no incentive to participate in the rulemaking process until the last minute, did you examine, in terms of the answer that you gave, the potential?
I'm not trying to understand the question. Do I believe that this will cause an endless cycle of
No, I
conflict?
didn't ask whether you believe. You're the counsel, so you're talking about law. And you rejected, well, Mr. Walden rejected or questioned my use of those words, and so did you. But I'm asking you if, in your answer, that you examined the potential of what this amendment would do.
Yes.
You did?
Yes.
And how did, under what statute did you find that, that what I put forward doesn't stand? Under what statute?
Well, pursuant to Title 47 of the Code of Federal Regulations and the FCC's rules on ex parte contacts and how they file their ex parte
And
commentary.
the possibility of litigation.
Well,
where does that?
I'm confused which question. Are you asking about the potential for an endless cycle of comments or the potential for litigation?
Well, you've already told me your opinion on that. What about litigation, in your legal opinion?
Under the Administrative Procedure Act, the FCC is not supposed to introduce anything in their final document that would not be contained in the underlying record.
But this is not a final document.
Correct. So if they're offering a draft that complies with the Administrative Procedure Act, that draft would not create any new litigation risk that does not exist with the final commission document.
Let me say something about the what's been said about this. I would like someone to explain to me how our system, which for all of this saying the public knowledge and the public should know everything that we're doing, the chairman and the ranking member meet to discuss bills. They don't put that out. They're not required to put that out in 24 hours. You met, I think, this morning before this markup. The Democrats met. The ranking member spoke about many things to inform members. And there were things that several of us didn't know. But they were part of the conversation that Chairman Upton and the ranking member had, which are absolutely appropriate. Was that posted? Did that go out to the public? No.
Would gentlelady yield?
No, I'm trying to draw a comparison. It's been said that we wouldn't operate this way. We do operate this way, and most frankly, those conversations and the knowledge that is shared and what comes out of them to the rest of the members is very important. Chairman Upton, Walden, and Thune wrote to Chairman Wheeler and asked that the draft order be released before other commissioners had an opportunity to review. Why? 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 Can't the commission do its work and then put the order out? It's not just the chairman. There are 5 commissioners. And I think that what they need to do is their due diligence, and then a combination of all of that goes out to the public. And that's not what is in, well, that speaks for itself. That January 22nd letter speaks for itself. And I don't know if the council has any legal opinion on that.
Could you repeat the question, ma'am? What's my legal opinion on what question?
On the January 22nd letter. Is there any legal ground on this?
Is there any legal ground for a member of Congress to request a document from an administrative agency?
No. I'm asking you if about the January 22nd letter, which I'm sure you reviewed because you're the council, that a draft order be released before the other commissioners had an opportunity to review. What is the legal standing of that? What are the legal merits of that?
Well, the chairman is solely responsible for deciding what the commission's output would be. So if the chairman of the FCC wanted to put that out, he was well within his rights to do so.
And leave all the other commissioners out?
Under the FCC's rules, he is solely responsible for that decision, yes.
What's the precedent for doing that?
I mean, it's not been done before, but it is permissible.
But there isn't any precedent for it?
None that I'm aware of.
Thank you. I'll yield back.
Gentlelady's time has expired. Other members wishing to speak on the amendment? Seeing none, the vote occurs on the Kinzinger amendment. Those in favor will say aye. Aye. Those opposed say nay.
No.
You need a chair. The ayes have it.
Mr.
The ayes
Chairman,
have it.
recorded vote.
Recorded vote is asked for. The clerk will call the roll.
Mr. Barton. Mr. Barton votes aye. Mr. Whitfield. Mr. Whitfield votes aye. Mr. Shimkus. Mr. Shimkus votes aye. Mr. Pitts. Mr. Pitts votes aye. Mr. Walden.
Aye.
Mr. Walden votes aye. Mr. Murphy. Mr. Murphy votes aye. Mr. Burgess. Mr. Burgess votes aye. Mrs. Blackburn. Mrs. Blackburn votes aye. Mr. Scalise. Mr. Lotta. Mrs. McMorris-Rogers. Mrs. McMorris-Rogers votes aye. Mr. Harper. Mr. Harper votes aye. Mr. Lance. Mr. Lance votes aye. Mr. Guthrie. Mr. Guthrie votes aye. Mr. Olson. Mr. Olson votes aye. Mr. McKinley. Mr. McKinley votes aye. Mr. Pompeo. Mr. Pompeo votes aye. Mr. Kinzinger. Mr. Kinzinger votes aye. Mr. Griffith. Mr. Griffith votes aye. Mr. Bilirakis. Mr. Billaracas votes aye. Mr. Johnson. Mr. Johnson votes aye. Mr. Long. Mr. Long votes aye. Mrs. Elmers. Mrs. Elmers votes aye. Mr. Bouchon. Mr. Bouchon votes aye. Mr. Flores. Mr. Flores votes aye. Mrs. Brooks. Mrs. Brooks votes aye. Mr. Mullen. Mr. Mullen votes aye. Mr. Hudson. Mr. Hudson votes aye. Mr. Collins. Mr. Kramer. Mr. Kramer votes aye. Mr. Pallone. Mr. Pallone votes no. Mr. Rush. Miss Eshue. Miss Eshue votes no. Mr. Engel. Mr. Engel votes no. Mr. Green. Mr. Green votes no. Mr. Gett. Mr. Gett votes no. Miss Capps. Miss Capps votes no. Mr. Doyle. Mr. Doyle votes no. Miss Schakowsky. Miss Schakowsky votes no. Mr. Butterfield. Miss Matsui. Miss Matsui votes no. Miss Castor. Miss Castor votes no. Mr. Sarbanes. Mr. Sarbanes votes no. Mr. McNerney. Mr. McNerney votes no. Mr. Welch. Mr. Welch votes no. Mr. Lujan. Mr. Lujan votes no. Mr. Tonko. Mr. Tonko votes no. Mr. Yarmouth. Miss Clark. Mr. Loebsack. Mr. Loebsack votes no. Mr. Schrader. Mr. Schrader votes yes. Mr. Kennedy. Mr. Kennedy votes no. Mr. Cardenas. Mr. Cardenas votes no. Chairman Upton.
Votes aye.
Chairman Upton votes aye.
Other members wishing to cast a vote? Mr. Latta.
Mr. Latta votes aye.
Other members wishing to cast a vote? Seeing none, the clerk will report the tally.
Mr. Chairman,
Gentleman
point
from
of personal
Oregon.
privilege,
Gentleman is recognized. Can we call the vote first or not?
however you want to do
Let me just call the vote first.
Mr. Chairman, on that vote, there were 30 ayes and 18 nays.
30 ayes, 18 nays. The amendment is agreed to. Chair would recognize the gentleman from Oregon.
Mr. Chairman, a lot was made about the January 22nd letter that was signed by yourself, me, and Senator Thune. And if I recall hearing multiple times my colleague from California make the argument that we asked for the chairman to publicly release the draft text of the open internet order before it was circulated to the other commissioners. I believe that was the case. We could go back on the record and listen.
Yeah,
That is factually wrong. Factually wrong. And I would like to have the letter entered in the record, because here is exactly what it says, and I quote, "Accordingly, we urge you to publicly release the draft text of the open internet order when you circulate it to your fellow commissioners." Not after, when. I'll be happy to share the letter as sent.
Would the gentleman yield?
Yes.
What I said was that the January 2nd letter 22nd, I'm sorry, asked that the draft order be released before the other commissioners had an opportunity to review.
And that is?
If you put it out to the public and the commissioners at once, the commissioners have not had the time to do due diligence, because it's all just put out there at once. And so I think that, I mean, I stand with what I said. There isn't any reason for me to try to twist something into something that it's not. I mean, I think that we're, all of us are much better than that. We may disagree on the amendment,
Reclaiming my
but
time.
do the commissioners and the public receive it at the same time?
We asked for it to be we asked for it to be made public when the chairman circulated it to the fellow.
Well, that's right, and for the commissioners don't have any leg up to do their work.
I stand.
Are there further amendments to the bill?
Mr. Chairman,
Gentlelady from North Carolina.
Mr. Chairman, I have an amendment at the
Clerk will
desk.
report the title of the amendment.
Amendment to H.R. 2583, offered by Mrs. Elmers of North Carolina.
Without objection, the text of the amendment is read, and the staff will distribute the amendment and consider it as read, and the gentlelady is recognized for 5 minutes in support of her amendment.
Thank you, Mr. Chairman. I am pleased to offer an amendment to H.R. 2583 based on my legislation that would require the FCC to publish its newly adopted rules in a timely fashion. My bill is a good government bill that would require the FCC to ensure that the public has timely access to the rules that will impact their everyday lives. While I recognize that this commission and the previous commission have made great strides towards ensuring that the public has access to the orders quickly after the commission's open meeting, there is no guarantee that this effort will continue with the next chairman. Currently, there are no rules surrounding the publication of the rules after adoption, and staff at the FCC is routinely granted editorial privileges on the adopting order, which may draw out the process beyond what is reasonable. My hope is that this amendment will help increase the transparency of the FCC rulemaking process, and so my amendment rightfully belongs in the FCC process reform bill. I hope you can join me in ensuring that the public enjoys the right to speedy access to the FCC rules. And with that, if anyone else would like to speak, I'll be happy to yield my time.
Gentlelady yields back her time. Other members wishing to speak on the amendment? Now the gentleman from Vermont is recognized.
I was
5 minutes.
overeager. Thank you very much. As I was saying before, there's two concerns. One is the publication, which lets people know immediately what the rule is, and then secondly is the explanation. Both are actually. Do you take a minute? Both are important. The practice in the FCC, as I understand it, is to release in general items on the day of the vote, and the vast majority of orders and new rules are public within 2 business days of the FCC. So as a practical matter, pretty much the orders get out in 24 hours or 48 hours. The real question is, in those situations where there's a very difficult case, it's not a routine case, is it better to give the FCC time to fully write the explanation that oftentimes addresses the very specific concerns raised by the minority in the vote on the FCC? Sometimes that's Democrats, sometimes it's Republicans. And in fact, I think getting that explanation is extremely helpful to the public. And the apprehension I have with the Elmer's amendment is that in situations where that explanation would be very useful for the public awareness of the basis of that order, the public would be denied it because the commission would have to meet this 24-hour deadline. So this is kind of a balancing issue. The speed with which the order is published at the expense of the explanation behind it, or in some cases, a delay beyond the 24 hours in order to provide the comprehensive explanation. If this had more time to it, it might work a little bit better, because I get the spirit of this. Sooner is generally better than later, but sooner without an explanation may not be better than sooner. So the amendment is drafted. I intend to oppose.
Will the gentleman yield?
Yes, I will.
Just to answer your question, the FCC has full ability to add additional information at a later date as they see necessary if there's miscommunication or they feel that the information that's been released is not adequate. So, I think it's open-ended, and look, this is a very common sense approach. I think that 24 hours is a very reasonable amount of time. We're not asking them to go, well beyond their means. 24 hours is reasonable. It's common sense. And I think this is something that will be good for the American people. And there again, they can add additional information. So, although that I can understand the concern, I think that it can be addressed at a later date.
Will the gentleman yield?
Yes, I will.
Yeah, just to Mr. Welsh's point, stakeholders need both the rule and the explanatory text to understand the decision. And so while I think the amendment's well-intentioned, you're really not giving people the information they need within the 24 hours. If they're getting the rule but not the explanatory text to go along with the rule, it's going to be longer than 24 hours before they know what they're reading. So I think the the criticism of the amendment is without both, you're really not getting the public information any faster. And that's the flaw in this amendment. I yield back.
Gentleman yields back. Other members wishing to speak on the amendment? Seen none, the vote occurs on the Elmer's amendment. Those in favor will say aye. Aye. Those opposed say no. No. Opinion of the chair, the ayes have it. The ayes have it. And a roll call is requested. Clerk will call the roll.
Mr. Barton. Mr. Barton votes aye. Mr. Whitfield. Mr. Whitfield votes aye. Mr. Shimkus. Mr. Pitts. Mr. Pitts votes aye. Mr. Walden. Mr. Walden votes aye. Mr. Murphy. Mr. Burgess. Mr. Burgess votes aye. Mrs. Blackburn. Mrs. Blackburn votes aye. Mr. Scalise. Mr. Lotta. Mr. Lotta votes aye. Mrs. McMorris-Rogers. Mrs. McMorris-Rogers votes aye. Mr. Harper. Mr. Harper votes aye. Mr. Lance. Mr. Lance votes aye. Mr. Guthrie. Mr. Guthrie votes aye. Mr. Olson. Mr. Olson votes aye. Mr. McKinley. Mr. McKinley votes aye. Mr. Pompeo. Mr. Kinzinger. Mr. Griffith. Mr. Griffith votes aye. Mr. Bilirakis. Mr. Bilirakis votes aye. Mr. Johnson. Mr. Johnson votes aye. Mr. Long. Mr. Long votes aye. Mrs. Elmers. Mrs. Elmers votes aye. Mr. Bouchon. Mr. Bouchon votes aye. Mr. Flores. Mr. Flores votes aye. Mrs. Brooks. Mrs. Brooks votes aye. Mr. Mullen. Mr. Mullen votes aye. Mr. Hudson. Mr. Hudson votes aye. Mr. Collins. Mr. Collins votes aye. Mr. Kramer. Mr. Kramer votes aye. Mr. Pallone. Mr. Pallone votes no. Mr. Rush. Ms. Eshue. Ms. Eshue votes no. Mr. Engel. Mr. Engel votes no. Mr. Green. Ms. DeGette. Ms. DeGette votes no. Ms. Capps. Ms. Capps votes no. Mr. Doyle. Mr. Doyle votes no. Ms. Schakowsky. Ms. Schakowsky votes no. Mr. Butterfield. Ms. Matsui. Ms. Matsui votes no. Ms. Castor. Ms. Castor votes no. Mr. Sarbanes. Mr. Sarbanes votes no. Mr. McNerney. Mr. McNerney votes no. Mr. Welch. Mr. Welch votes no. Mr. Lujan. Mr. Lujan votes no. Mr. Tonko. Mr. Tonko votes no. Mr. Yarmouth. Ms. Clark. Mr. Loebsack. Mr. Loebsack votes no. Mr. Schrader. Mr. Schrader votes aye. Mr. Kennedy. Mr. Kennedy votes no. Mr. Cardenas. Mr. Cardenas votes no. Chairman Upton.
Votes aye.
Chairman Upton votes aye.
Other members wishing to cast a vote? Mr. Shimkus.
Mr. Shimkus votes aye.
Mr. Green.
Votes no. Mr. Green votes no.
Dr. Murphy.
Dr. Murphy votes aye.
Ms. Blackburn, are you recorded? Yep. Other members wishing to cast a vote? Seeing none, the clerk will report the tally. One more.
Mr. Chairman, on that vote, there were 29 ayes and 18 nays.
29 ayes, 18 nays. The amendment is agreed to. It's my understanding we have one amendment that is going to be offered left. That may be wrong, but it's my understanding there's only one left. And the chair will recognize the gentleman, Mr. Latta from Ohio.
Well, thank you, Mr. Chairman.
Who has an amendment at the desk. The clerk will report the title of the amendment.
Amendment to H.R. 2583.
Amendment will be considered as read. The staff will distribute the language, and the gentleman is recognized for 5 minutes or less in support of his amendment.
Thank you again, Mr. Chairman. I'm offering an amendment based on my bill to require the FCC to list and describe all items to be adopted on delegated authority. We've all heard lately the troubling reports that the chairman may be delegating items that should be considered by the full commission for open debate and discussion. This is not how American government should operate. It is inappropriate for the commission to delegate items that pose new and novel questions of policy. Those items should be considered and voted on by all the commissioners. My amendment would remove the suspicions of any abuse of delegated authority by requiring the FCC to list and describe on its website all items to be adopted on delegated authority a full 48 hours in advance. Opponents of my draft bill argued that too many items are taken on delegated authority, and the FCC would be burdened by the number of items that it would have to notice in advance. I'm not entirely convinced by the argument, given the FCC's current practices to publish a list of all items, including items taken on delegated authority on a daily basis. Nonetheless, the intent of my amendment is to ensure that transparency and that it does not create burdens. That's why in my amendment to require the listing and description of only those delegated items that received a DA number from the FCC. As I understand, these items are given a DA number by the FCC bureau chiefs who consider whether the decision will have precedence in the future and whether the item is an issue of broad public attention. I believe that these are the items we would like to capture by the 48-hour notice. This amendment reflects that modification, and I believe will give greater transparency and openness to the Commission. And also, as we saw, and I believe that in the subcommittee markup, when we were talking about this issue, that in 2014 there were 1,845 DAs that were assigned numbers, and if you break that down, that's only 5 per day. So I don't think that's overly burdensome for the Commission to have to come up with. Even if you go back in the last 4 years, it'd be 6.6, 5.5, or 5.6 per day. So, Mr. Chairman, I would ask for the adoption of the amendment, and I yield back.
Gentleman yields back. Other members wishing to speak on the amendment? Mr. Doyle is recognized for
Thank you,
5
Mr.
minutes.
Chairman. I move to strike the last word. Mr. Chairman, my friend and colleague, Mr. Latta's goal of enhancing transparency at the FCC is admirable, and I'm all for that. But this amendment doesn't really achieve that. Instead, this amendment effectively delays many FCC actions by 48 hours arbitrarily. The FCC acts on delegated authority thousands of times each year, and it's done that under both Democratic and Republican administration. The vast majority of these actions are non-controversial by any standard. And while the amendment states that summaries of these decisions should be published 2 days ahead of their release, much of this work is currently released as soon as it's approved by the Bureau. So the actual effect of the Latta amendment would be a 2-day delay in creating an unnecessary hurdle by delaying full release of these decisions to the public and penalizing the businesses and stakeholders on which rely on the FCC. I appreciate that some changes have been made since we raised some concerns about delegated authority, but I still think the language in this particular amendment continues to be fundamentally flawed because it artificially delays thousands of routine and non-controversial items that the FCC processes annually. We're talking about things like public notices, division and bureau-level decisions, bureau-level petitions for reconsideration. These are non-controversial routine matters. And let me state also that all actions that are taken on delegated authority can still be appealed to the full Commission. That's a right that's always been maintained, and it's frequently exercised. So I would just say that this amendment is flawed and not worthy of our support. I'll yield back.
Gentleman yields back. Other members wishing to speak on the amendment? Seeing none, the vote occurs on the amendment offered by the gentleman from Ohio. All those in favor will say aye. Aye. Those opposed say no. No. Need a chair. The ayes have it. The ayes have it, and the amendment is agreed to. Are there further amendments to the bill? Seeing none, the question now occurs on favorably reporting H.R. 2583 as amended to the House. All those in favor will say aye. Aye. Those opposed say no. No. You need a chair. The ayes have it. The ayes have it. And the bill is favorably recorded. And without objection, staff is authorized to make technical and conforming changes to the bills reported by the committee today, so ordered and pursuant to House Rule 11.2.1. All members will be given 2 calendar days to file written and signed views for the bills approved by the committee today. Without objection, the committee stands adjourned.